SJC-12238, Commonwealth v. Cassandra B. Littles.
Morning, Mr. Kenyon. Give us a moment.
Yes, sir.
Okay.
Good morning. May it please the court, my name is Joseph Kenyon. I'm the attorney for Cassandra Littles, the appellant defendant in this matter. In this case, as you know, it's about the alleged or proven passing of bad checks. Ms. Littles passed a total of 4 checks over a 4-day period, 2 on one day, 1 the next day, and 1 2 days later. She deposited them in the same bank, a couple of different accounts in the same bank. She was informed, at which she had an account. She was informed, the record is not quite clear on exactly how many days later, but within a couple of days, she was informed that the checks had bounced in the common parlance.
There was other evidence, though, besides that, right? I mean, there's the documents that were before the jury, which would also indicate that she had moved the money rapidly between her 2 accounts as if to take advantage of the delay in processing the checks. She spent an abnormally large amount of money in that period. There was other evidence.
There was other evidence about how she moved money around. I'm not sure about abnormally large amount of money, but she spent a lot of money. She spent about $10,000 or $11,000, I believe, in the next several days.
Well, the bank was short about $11,000, right?
That's correct, Your Honor.
So the core of your argument, though, is that common sense and logic don't let you get from, if the basic fact is proven, that
I'm sorry, Your Honor, if what was proven?
if the basic fact is proven, that you can't get to that resultant fact that there was an intent to permanently deprive at the moment the check was made. That you're saying there's not, based on the client dissent, there's not logic that flows from that information, like the logic that flows that if you mail a check, that the check is received. So the problem here is, from your view, there's no common sense and there's no logic between the basic fact to be proved and the resultant fact that the jury is informed of.
That's correct, Your Honor. The basic fact being the fact that once she was notified that the checks had bounced, she did not repay the bank in full within 2 days.
Now, if she hadn't taken the witness stand, and so we don't call these in criminal cases rebuttable presumptions. They are. We don't call them that. We call them permissible inferences, yes, to not confuse the jury. But if your client hadn't taken the witness stand and the resultant fact was never rebutted, would Judge Ehrlich's instruction have been okay in your mind?
I believe not, Your Honor. It would still require a leap of logic that I think logically does not make sense, as the 2 dissenting judges in the Klein case said. The fact, it could be possible that she was confused. Certainly her testimony in many respects, as well outlined by the Commonwealth in its brief, displayed confused thinking on her part for approximately from about the time of this incident until the time she was testifying, frankly.
But that doesn't matter if there's common sense and logic that flows. It doesn't matter that it's rebutted.
She could have been mistaken, that the checks that she deposited, there was sufficient funds in the account on day 1, or the several days where she deposited them. A few days later, when she was told by the bank that there had not been sufficient funds, the fact that she failed to repay within 2 days, I think, does not logically show what she knew back on day 1, on the first day.
Suppose it wasn't 2 days. Suppose it was just, a failure to repay.
If there were no time limit,
Right,
no number of days, I think logically that would actually make more sense. And along that regard, I'd like to point out that the Commonwealth cited, I believe it was 30 by my count, other jurisdictions, mostly states, but also District of Columbia, Virgin Islands, and Puerto Rico, that have somewhat similar statutes. I don't know if that's an exhaustive list, but that's the number that they put in their attachment to their brief, supplement to their brief. No other state of those has only a 2-day limit. 6 of them have no time limit at all, and the shortest, several states have 5 days, some have 10. At least one, I believe, has, well, 16. I thought there was a 30. I'm looking down my list. I don't see 30. But at any rate, Massachusetts is the only state of those cited by the Commonwealth that has only 2 days. And in that regard also, I would point out that when the statute was first enacted in 1919, it provided for 10 days for a reason I don't know. I wasn't able to determine from legislative history. In 1937, it was amended to reduce that 10 days to 2 days.
That was a question I was going to ask you, and I certainly don't know the answer to this, and maybe you can help us out. Where does, since Klein, where does the proliferation of electronic banking come into play? Does that help you or hurt you?
I see the Commonwealth argued in some detail in its brief that in these modern days, there's sort of no excuse for having an overdrawn bank account, that anyone can pull out their cell phone and check their balance. Well, anyone isn't necessarily this defendant.
But she did online banking, didn't she?
I know she had.
Is there evidence of that?
She did electronic, yes.
So she's familiar with the electronic banking.
I'm not disputing that, Your Honor. I'm just saying, I believe Justice Graziano was asking in general about the concept
Yeah,
of
but then you
electronic.
started to move to the fact that there's no evidence that this person did, and I was suggesting.
If I said
kind
that,
of- Okay.
it was a
Yeah, I assume we have no empirical evidence to indicate that people are writing less bounce checks now in the world of electronic banking than they did 10, 15 years ago.
none that I'm aware of, Your Honor.
Let's go back to the statute, which I guess is where the instruction comes from, sort of. It says it shall be prima facie evidence of intent to defraud. What does that mean?
Well, as interpreted by the courts, the prima facie has been sort of restated as allowing, in criminal cases, as allowing a permissible inference. A jury ends up being instructed, as they were in this case.
Oh, it allows more than that. It allows that the permissible inference to remain even if it's rebutted. Doesn't disappear.
Right. Well, I'm focusing on the jury instruction.
Right.
The legal significance of prima facie is, as you say, Your Honor, if this were a case of sufficiency of the evidence, that I guess that distinction would be more relevant. I'm focusing on whether the jury, having been told about the permissible inference regarding the failure to repay.
I guess that's what I'm getting at. Does prima facie evidence mean that if the only evidence in this case was that she wrote a bounce check and failed to pay it in 2 days, that is sufficient to reach the jury and survive a motion for required finding?
I think that would be the logical consequence of.
Well, what did we hold in Klein on that, in that regard?
I'm sorry?
What did we hold in Klein in that regard?
In Klein, the majority did not reach the decision. It did not reach that issue. The court, the statute had been challenged on void for vagueness grounds and other grounds, but not specifically, or if it had been challenged, the court chose not to reach the issue of whether this 2-day delay clause was unconstitutional, whether that was a deprivation of due process or shifted the burden. Because in that case, as I recall, the court discounted the final paragraph of the instruction of the jury instruction says that if there is contrary evidence, the jury is free to disregard the permissible inference. And in that case, there had been evidence to disregard. There had been evidence to counter the permissible inference. So the court said, therefore, we're going to presume the jury followed our instructions and followed the court's instructions and did not count the permissible inference.
Mr.
in
Kenyon,
its recounting of evidence.
do you think that a permissible inference that a person in possession of recently stolen property knows that it's stolen?
I believe there's more logic to that than this. The problem here is the temporal differentiation. It requires the jury, or allows the jury, to go back to an earlier state of mind based on a leap of logic that I don't see. In
Yeah,
logic.
see, that's the point of my question. The point of my question is, you're not really arguing on constitutional grounds that there's any burden shifting here as a general principle of permissible inferences. You're saying that the constitutional issue here, which is not the issue in Ulster or any of these other Supreme Court cases, is that no common sense or logic flows from getting from the basic fact to the resultant fact.
Exactly, Your Honor. I think the Commonwealth and the defendant agree that that is the nub of the issue here. It's not a case, as was before in unclear, before these enlightened times, when presumptions were allowed to be stated as such, and then it was feared that a jury will say, well, presumption means we have to presume that that fact has been proven. And as you know, that language has been changed. The Commonwealth cited, I have my numbers here. The Commonwealth cited, along those lines, they cited, I believe, 16 other statutes in Massachusetts that they say allow, and I don't think they were contending that was an exhaustive list, and I did not create an additional list. But they cited 16 statutes that provide for permissible inferences. Often the statutes, when one looks at them, don't use that phrase. They use prima facie evidence. But of the 16, only one is anything like this. And it looks like it was probably, it's Chapter 151A, has to do with unemployment insurance, and then Section 47A, which has to do with, it appears in the statutory scheme to have to do with repaying prior overpayments to the unemployment fund and using a bounce check. The provision's basically, it's exactly the same. If you use a bounce check, or if your check bounces and you fail to make good within 2 days, the same permissible inference is there. The other cases are all different from that. None of them that I can see require this. They make more sense. They make logical sense. In other words, several of them have to do with defacing the serial number off a motor vehicle. If you own a motor vehicle with a defaced serial number, it's logical that maybe you knew this was a stolen motor vehicle. Or deface, if you have a firearm with its serial number defaced, maybe you knew that was not a legitimate firearm.
Well, how about this analogy? I don't know, Corella versus California. I don't know if you looked at that United States Supreme Court case, but if you don't return a rental car within 20 days, there's a presumption that you intend to keep the car and deprive the rental company of the car.
That's I'm not familiar with the case per se, but that one of the Commonwealth's one of the statutes cited by the Commonwealth, which I was going to get to, provides, it's Section 187 of Chapter, I believe it's 266, larceny of leased or rental property, or rented property. And in that statute, the statute provides, among other things, that if one receives a demand from the actual owner of the property to return it and fails to return it within 10 days, then it can be, it's permissible to infer that the person is intending to steal the property. I think that's something like the case that you're saying. But that's saying, it's not saying that on day one the person intended to steal the property, the car in your case, or any property under the Massachusetts statute. It's failing to respond within 10 days by returning it, the property which presumably is in one's possession, that falls afoul
Counsel, may
of
I
that
ask you,
statute.
it wasn't actually 2 days in this case, it was a long time. So the 2-day presumption in the statute doesn't really affect your client because she was notified and she promised that she would pay when she got back from out of town. They sent her a letter. It appears that the bank was very lenient in this case. So the 2-day rule is not really a problem for your client.
Well, it's irrational still, Your Honor. I agree, though, and she was actually misled. I would argue the bank sent her a letter in August, a couple of weeks later, saying pay up within, I think it was either 10 or 14 days. She didn't do it. Now that would suggest to a defendant, a person who has overdrawn their account, oh, I have 10 or 14 days, whatever the number of days in the letter was, before I'm going to be in real trouble. Then months later, for a judge to tell a jury, guess what, if she was 2 days late by August 3rd or something, 2 weeks before that letter was even sent, she already could have been prosecuted. I think it sort of leads her down the primrose path in the wrong direction.
That,
Yes, Your Honor.
sort of brings me to the question of, in federal court, it seems like this is not a question to be settled in the abstract, but based on the facts, the particularized facts. Is that also our rule?
I believe so, Your Honor. The phraseology is whether, from the cases, is whether the inference is rational within the facts of the case or within the evidence of the case. Here, I just don't, I see no rational application of the theory that because she failed to return the checks by, call it August 5th.
Yes, but I guess in connection with Justice Hines, do we not consider that she had a lot longer than 2 days?
I don't think, well, for whether the Commonwealth proved its case apart from the inference, yes, I think so. But for whether the inference itself or the jury instruction regarding the inference is rational, I don't see how that delay changes the logic.
Well, I mean, assume you're right. Assume that it's not rational.
For a moment.
The evidence against your client was rather compelling. Why is the error not harmless?
Well, we, of course, presume that juries follow a judge's instruction here.
But the instruction was permissive.
It was permissive.
It said they may consider it, and you're saying it's an irrational, and so why couldn't the jury say, well, that's not a terribly good reason, but we got plenty of really good reasons for finding that she knew what she was doing?
They could have, and absent the instruction, it would have been a rather stretched argument to say there was insufficient evidence to prove her, but to convict her. But to prove, as you know, if one assumes that the instruction was faulty, then the question is this court convinced beyond a reasonable doubt that she would have been convicted anyway? And I would say that the judicial sort of, putting the thumb on the scale, even just a light weight, only adding slightly, somewhat, to the Commonwealth's case.
Isn't your
it's hard to
argument?
say what would have happened otherwise.
I'm sorry. Isn't your argument that in this case that the defendant took the stand, gave a different explanation, and that therefore to have that instruction with the permissible inference of not handling the account within 2 days really augments the prejudice? It augments the prejudice, and I think your argument is even not based on common sense and logic problems, that the jury shouldn't be instructed when the resultant fact is rebutted.
Well put, Your Honor. That would be part of the rationale, part of my argument, yes.
All right, thank you.
All right. Thank you, Your Honors.
Good morning, Mr. Chief Justice, members of the court. My name is ADA Phil Mallett here on behalf of the Commonwealth today. I'm joined by Lindsay Nason, the trial prosecutor who tried the case. I think this court has sort of moved past the first issue, which is whether these instructions set a mandatory presumption or a permissive inference, and I think the instruction certainly did state a permissive inference. But to really jump upon Justice Lenk's question about whether the federal courts consider this in context of the trial evidence or in the abstract, I think it can only work a due process violation against the defendant if, in light of the entire trial evidence, this instruction put the jury in a position to infer a fact that was irrational. And based on this evidence, even the evidence just from the Commonwealth's case, not even including the defendant testifying, the inferences, the two inferences, knowledge and intent to defraud, were certainly rational just from the evidence that was discussed before about moving money around, the quick spending of the over $11,000. That, I think that alone takes those two inferences and puts them in a context of a larger presentation of evidence. Now, I think because of that, there is not a due process violation here with this instruction as provided to the jury on that day for this trial on this evidence. And based on that, I think this court should affirm. If the court were to step beyond,
Should affirm, well, at best, it is a very weak inference.
I think I look at it a little differently than I think what Your Honor is getting at. The two-day basis is simply the floor by which the inference arises. In this case, it was well over a year, and even until the time of trial, so we're getting into nearly 2 years. The inference arose after 2 days, but we're dealing with over 18 months. So the jury was certainly able to make that inference after 2 days, but they were in a position to consider the full 18 months on the failure to repay.
But the bank said, essentially, if you pay us back in 14 days, we're content.
Correct.
And that letter probably wasn't even received until it was sent by snail mail, correct?
Correct.
So probably wasn't even received for more than 2 days after this thing occurred. So 2 or 3 or 4 days after this, they say you've got 14 days to pay. They don't say you've got 2 days to pay, and the failure to pay will cause us to believe that you intended to do so. So, I mean, I understand that one can make some inference. One could argue that you should be keeping track of your account, but it seems at best an extraordinarily weak inference, and so why should we be telling juries this?
Well, it's because of this, Your Honor, and this is what I was going to get to anyway. These inferences will always arise in the context of other evidence, and in the rare instance where they do not, and I'll take Your Honor's hypothetical, let's say there was no other evidence as to intent to defraud and knowledge. In this case, there was a closed account. I think that puts it well beyond, in a far different posture. If it was another account at another bank open, and there was no other evidence as to intent to defraud and knowledge of insufficient funds, that inference set by the statute would have to suffice to prove beyond a reasonable doubt. In this case, as it generally arises, it's a different scenario because the inference need only be more likely than not, as stated in Ulster County. But in the context of when it's the only evidence, when this inference is the only evidence, then it must rise to the level of beyond a reasonable doubt. Now, I think taking your hypothetical to the next step, let's say she doesn't pay within 2 days, and on the 3rd day, she does pay and is still charged. And there's no other evidence, and this statutory inference is the only thing that exists. I think that case is the exception to the rule, and I think considering this inference, which is going to be generally applicable, and generally applicable in cases where there is other evidence. The prima facie statute is not meant to exist in a vacuum, I don't think. I don't think any evidentiary device like set by statute is meant to exist in a vacuum. It's always going to arise in a case. It's always going to arise in a case where a directed finding, a directed verdict motion has been denied, because it wouldn't go to the jury otherwise.
So what does prima facie evidence mean?
It means that
They shall be evidence of. It says shall be prima facie evidence of.
And that's not what the instruction talks of.
correct. So the prima facie evidence is that this fact of failure to pay may allow the jury to infer that there was a knowledge and intent. May, you need not, and if there's other evidence, you can consider that, and you need not buy into this inference all the way.
But isn't, the point is, it being prima facie evidence, to go to Chief Justice Gantz's question, is that the inference remains and satisfies the burden of production.
I'm not sure it always does in the context where it's the only evidence that exists.
But that's what prima facie means. I'm not sure this inference does, and maybe none do, but that's what prima facie means, is that even if the resultant facts were rebutted, that you satisfy the burden of production, which I think goes to the real core of this case, and which is getting to Ulster County, whether or not there's a rational connection, there's logic. That's what we're really trying to understand. Put the facts of this case and the sufficiency of the evidence aside, and just look at this instruction so that we can try and understand this instruction.
So just after 2 days.
Yeah. Is there a, right, forget this case, is there a rational connection between the fact that has to be proven and the fact that you swing to that is the resultant fact of the inference, of the permissible inference? Where's the logic in that?
Well, this is really where you have to focus on the nature of what a check transaction is. I took commercial paper, it was on the bar, but it's not something I think that comes up quite frequently. Larceny by check is a separate crime because the person who's obtaining the goods, services, or money is in fact tendering an order for a third party, that is the bank, to pay the person from whom they're receiving these goods, services, or money. So there's an entire apparatus of banking that's involved. And it's reasonable to infer that when the legislature set this prima facie rule, that they were considering the entire panoply of apparatus that are, basically it's not just I'm handing someone $10 and receiving $10 or something in value. I'm, in fact, causing my bank to pay money to the person to whom the check is tendered. And because of that, it's a highly regulated, essentially, transaction. The UCC imposes all kinds of presumptions and burdens in the civil context because it's not simply like a typical larceny, and that's why the statute has to exist in order for this to be a crime.
But you could sort of feel Justice O'Connor's concern in the Klein dissent. It was palpable. I mean, I felt like he was thinking what I was thinking. Geez, 2 days. I'm not that good sometimes with my checking account. I wouldn't want to have this permissible inference against me. I mean, the issue is whether it flows. You give something to a bailor, and you're waiting to get it back. And it's going to be delivered back in 15 days. There's what we call permissible inference, what used to be called a rebuttable presumption on the civil side, that during those 20-day period, if it's destroyed, that the bailor destroyed it. So that flows from common sense. It flows from logic. And I'm not sure, as well as you stated it, how this flows from logic.
Well, in this case, and I'm sorry, in the context of larceny by check, there's going to be, it's not just 2 days after you give someone the check. There's going to be processing time, so there's at least a negotiating period. There's going to be a moment for the person who's been, the person from whom you got the goods saying, look, that check you just deposited or tried to cash was dishonored. So there's processing time and lead time that goes into it. It's not as if I give you the check on Monday and I'm going to get notice the same day. So there's a little bit more of a buffer time in terms of the 2 days.
It's 2 days after the person has received notice?
Yes. So there's going to be also mailing time. I'm not sure anyone would proceed to trial on this without actual notice. No one's going to say, I think notice has to be proven, and oral notice, I'm not sure. Verbal notice is not going to be, it possibly could satisfy the statute, but written notice, I think, is the preferred practice. So there's the mailing time for the certified mail, for the notice of the fact that it's been dishonored. So you're getting beyond the 2 days. And in that context, it's a matter of what did the person do with the things they received in exchange? Did they dissipate the money, spend it all within 3 days, or within the period before they were notified? if it, in this context, that's what happened. If it's a situation where I'm getting something in exchange, if I'm getting a tractor, I give you $10,000 check, I get a tractor, check's dishonored. To make good on the check, I can simply return the tractor, and that can be accomplished quickly, perhaps not as quickly, but I can certainly see the court's concern that if I'm in California and I'm trying to return a tractor to Massachusetts where I bought it from, and my check bounced to a Massachusetts tractor seller, that I couldn't actually get that tractor back to the possession of the Massachusetts buyer in 2 days. It certainly is a 2-day period that I think is at the far extent of what is permissible for due process. I would note that there are other states that create the presumption simply upon the making of a check from an account that does not have sufficient balance to cover it. So the real, I guess, ramifications of such statutes, and really our statute as well, is that it imposes a burden on a person drawing a check, making a check, to know their balance and to know what checks that they are issuing. And mistake or erroneous bookkeeping are handy defenses for criminals and people who would profit by these schemes. And I understand that there's a reluctance to impose such prima facie considerations. But that being said, the legislature made this permissive inference for a reason, and it's not necessarily universally adopted, but I think there's definitely a majority of states and some of the other territories have adopted similar provisions.
So is it your argument that it's not for the judges to determine what flows from whether it is common sense and experience, it's for the legislature to make the determination? That that its view of what makes sense is what matters?
This court should certainly consider the issue when it works a due process violation upon a defendant. And in response to that question, I would say, in the context of the whole trial, all of this evidence, did it work a due process violation upon the defendant? I would state no, based upon the strength of the evidence, other than the inferences. So all these legislatures and legislative bodies are considering the reasonableness, the rationality of the inferences to the basic facts. There's at least 30 that I could find that do make that rational connection sufficiently enough to put it within their enumerated legislation. That being said, there are there's many more examples of such prima facie presumptions in a larceny by check context that I didn't put in because the language isn't as similar. This is effectively word for word with differences of dates. And I think my brother's right. My survey of the states, which I put together, was as exhaustive as I could make it under the same text that we're dealing with here. And I certainly was exhausted making it, and I think it is exhaustive. Wisconsin's 5 days, Virginia's 5 days, Michigan is 5 days. Maryland and New York imposed the prima facie inference upon the making. And I think California does as well. So those happen at the time of the passing of the check, at the time it's drawn up. So if those statutes are rational.
Have they been challenged?
I'm not sure directly. I had a lot of difficulty finding cases contesting the check statutes specifically. I can tell you that page 33, note 31, has some cases on point that I could find. I know Maryland has been challenged. Maryland is making. So Maryland is a step beyond even what we have. And I would say this court is obliged to consider it under the federal constitution. I'm not sure there's a means by which the state constitution could afford a defendant a greater due process right to the rationality of.
Why is that?
I was trying to formulate this argument as well in preparation here. The federal standard is what is rational, common sense, and flows.
Maybe we don't accept the U.S. Supreme Court's view of what is common sense, and we have our own view, which we consider more commonsensical. Are we barred from doing that?
I personally had difficulty articulating what would be a standard of heightened rationality or more than rational, which I think if it's not rational, it might veer into the irrational, but I certainly don't, I don't disagree with the court on that
Let me ask you
point.
one more question. Do we have to worry about ability to pay? I mean, I understand that if Bill Gates bounces a check,
Different
we
story.
may expect him to pay it within 2 days. But if somebody bounces their check to pay the rent and their disability check is not going to come for the next 10 days, they may have no reasonable ability to make good on that until the disability check comes in. Is this statute and this inference unfair to the poor?
I guess, does it work a onerous due process violation upon those with an inability to repay? First, I would say that if the person received goods that could be returned, it would not. If the person received services that could not be, I guess, returned, then it may. But I'm not sure this court should consider that in the abstract. The defense here was not essentially inability to pay. In fact, it was quite the opposite. She had received considerable amount of money in the calendar year that's at issue here. It was always, I'm gonna pay, I'm gonna pay, I'm gonna pay, and never actually intended to pay. Never, I mean, it was drawn from a closed account. Her explanation at the time was that she believed it was her tax refund. She had spent that before. But I guess just in the abstract, Your Honor, to briefly answer the question, I don't disagree with you that it might have the potential for working a due process violation, potentially, but I'm not sure that this court should consider the question on these facts in this circumstance, especially when poverty and inability to pay were not defenses raised at trial. In fact, it was quite the opposite. It was, she offered the agreement to pay as an exhibit in evidence, and it was her entire position from the get-go that she wanted to, she just forgot.
Couldn't Chief Justice Gantz's concern be addressed if there is contrary evidence like there is here, where the defendant says, no, I intended to do so, that you don't get the permissible inference instruction? So in other words, the permissible inference instruction, if it flows from common sense, would be available, but if it's rebutted, it would be like we learned in law school, the bubble would burst and the presumption would disappear down to an inference, and the jury is not necessarily instructed on inferences.
Well, I was thinking about this question too, and the prosecutor can certainly argue common sense inferences, rational
Right,
inferences from the
exactly.
evidence. If this court were to find that this inference were not rational, then prosecutors would be barred from arguing because it flows from the same basis, that is common sense. All inferences must flow from common sense. And if this court rules that this inference in the statute is not commonsensical or requires some heightened standard, then prosecutors would be barred from making that argument in closing unless other standards were satisfied, however this court would consider them to be framed. And I don't think that that's the type of uniform statement of the law that should exist with respect to not only evidentiary rulings and standards, but also the standards and practices governing closing arguments and what inferences can and cannot exist based upon certain facts.
All right, thank you.
Thank you very much.